I am Brodie Butland. For those of you who don't know me, I'm an attorney in the Cleveland area, and proud to say this is actually the first year I can say I'm a partner with my firm of Porter, Wright, Morris, and Arthur. So, feels very good. Before I begin, I just want to sort of acknowledge all the speakers that have come before me, both on Friday and then also yesterday. This is the fourth year I've been here. Every year I think it can't get better, and yet it somehow does. And I think it really it's a testament to the quality of coaches we have here and the interest that you all have, not just in coaching, but also in other areas and the help that you can give. So I really appreciate all of your efforts and also the ones that will be following me. My job, of course, is to keep you all from falling asleep for about an hour and a half while I talk about legal issues, which tend to be a little dry, but I'll do my best. And I'm supposed to go an hour and a half. As you can tell, I'm filibustering a little bit for time just to make sure I fill it, but we will move on. So anyway, this is, as I said, Esquire SSC, and last year I got the title All-Around Awesome Dude. I gave it to myself, just like Charlemagne. And so just a couple things before we begin, just some CYA stuff, because of course, just because I'm presenting here doesn't mean that I'm your all's attorney. So, for example, this is for educational purposes only. The opinions expressed herein, though brilliant and inimitably well presented, are solely mine and do not necessarily reflect that of any other person, including my firm, Porter, Wright, Morris, and Arthur. Should not be construed as legal advice or create an attorney-client relationship. You are free to call me anytime. My contact information was on the first slide. I do have a few business cards if you want to talk afterwards, but I'm just trying to do this for educational purposes only. And then last, don't try to solve your legal issues with Google. Just try to actually get a real lawyer. The first time I did one of these presentations and I tried to find examples of bad waivers, I just Googled personal training waiver to pull examples. I found 6 examples on the first page of waivers with problems. So be careful what you find on the internet. I mean, I know, it has to be right because anybody can correct it, but still, you gotta beware a little bit. So things that we're gonna cover today, we're going to start with case law updates. Big surprise, we're gonna cover waivers at some point in this. Then we're going to go into Title II and anti-discrimination. Title II is the Civil Rights Act that effectively ended Jim Crow, but it also has implications for us, for those of us who run businesses, and for those of us who run competitions. So we'll go into that. We'll then go into deceptive trade practices and false advertising. In particular, I want to focus on using testimonials and endorsements, because that is a primary way that we advertise, and I think we need to be careful about what we do there. And then CrossFit NSCA. There's not really going to be a whole lot that we can change our business on by knowing that case, but I think it's really interesting. It's, the fitness industry is writing a lot of articles about it, and it's gotten a lot of attention, so I think it'd just be interesting to talk about what actually is going on in that case, where it is right now, where it's going, what the implications may be. So, I guess that'll be sort of like the really fun end part of the presentation where we can see how badly CrossFit is kicking around the NSCA. So first things, as I began, we're going to start with the written waiver. And as I say every year, and I'm sure that some of you are getting sick of this slide, but I'm going to go through it anyway, there are 4 general requirements to keep a waiver valid. One is it's conspicuous. You have to be able to see it. It can't just be buried in the middle of 8-point text on a 4-page form. It has to fairly cover the circumstances at issue. This is the who, what, where, when. If you're going to waive your own negligence, you have to expressly state that. I, of course, always say just use the word negligence because there's no confusion, but sometimes you can get away with different language. But again, I like to CYA as much as possible. And then you can't waive intentional misconduct, and intentional misconduct also includes things like recklessness or willful blindness, basically an extreme lack of any care whatsoever. So we'll just go through some case examples that deal with each of these issues. So first with conspicuousness, those of you who have heard me talk in the past, and those of you who have retained me to do waivers know that I like to do the waiver separately from the membership agreement. And the reason why I do that is because then there's no question what they're signing, right? The entire document is all about how they're going to lose if they try to sue you later. And so I think that's valuable for the conspicuousness. But if you're going to put it in the membership agreement, and there may be business reasons why you want to do that, just make sure you do it right. And so I think that this Evans v. Fitness Sports Club out of the Eastern District of Pennsylvania is a good example of what to do if you want to put it in a membership agreement. So in this case, it was a 3-page membership agreement. The waiver appeared on page 2, and the signature page was on page 1. So we kind of, there might be an issue there with conspicuousness, but this particular gem put the waiver in larger type than all the other provisions. It was in bold and capital letters for a heading right before it, so it was very hard to miss. And then on the first page, there was an entire segment right above the signature line that said, I want to represent that I have read all of the provisions, and then it specifically identified the waiver provision. It said including this waiver provision, which it then bolded, underlined, and put in all capital letters. So there was really no way that the person could possibly read this agreement and miss the waiver clause. So, so bottom line is, and the take-home message is, if you want to put waivers in as part of a larger agreement, just for business reasons, or because you think it might be daunting to a client to, have a whole bunch of pages of waiver on a separate document, just make sure you offset it. I mean, make it very obvious. Bold type, capital letters, underline, all of that stuff is good, and larger type. So that's it for conspicuousness. Let's go to fairly covered circumstances. Stone v. Lifetime Fitness out of the Colorado Court of Appeals. So in this case, the plaintiff tripped over a hidden electrical cord in the locker room. So it was the way that it was under the sink, there you couldn't really see it, and she ended up tripping and injuring herself, and she brought suit. And so the gym naturally defended on their waiver, because that's always the first line of defense. That's why I cover it so much. Now here is the waiver at issue. And I'm going to let you all read it a little bit, and I paraphrase some of it because it was really long, and there's no way I could fit it on a slide without putting it in 9-point type. But basically it has the inherent risk of injury, whether caused by me or someone else, in the use of or presence at a Lifetime Fitness center. And then it listed several risks, explicitly listed some of the risks because this is a full-service gym. And then it listed various injuries that were all training related. Your usual, broken bones, herniated discs, all that sort of thing. So who thinks, by raise of hands, that the waiver covered this circumstance? 1, okay. And who thinks it didn't? Okay, we got 2. Okay. What's the reason why it would have been covered? Either one.
In the use of or presence at a Lifetime Fitness.
Mm-hmm. Right, yeah, it says expressly use of or presence at, right? So that could be, that would suggest that this covers premises liability as well. Now, what's the best argument for no? Yeah.
There's a trend and a build-up that everything that they're talking about is training, use of the facilities, sport action,
Mm-hmm.
not just going to the bathroom or using the locker room. The locker room is in a stated location that
Exactly, yeah. Everything that's talking about this relates to injuries that are in connection with training. There's
The use of equipment and services, right? The bathroom, the locker room is a service.
Yeah. So, and now there's actually a statutory canon called the Justum Generis. We like to use Latin terms because they're fancy. I call it the hug canon. It basically means that if you have a bunch of words together, that they all kind of help interpret each other, so they're all hugging each other. And it's sort of the same idea here, right? I mean, this is basically the hug canon if we're saying no. Well, the court held that it did not apply to this particular instance. And there were a couple reasons. One of the main reasons is exactly what's been pointed out, is that all of these things relate to training injuries. They really don't talk about injuries in the premises. And one of the things that the court considered in contrast was an Ohio case from a few years earlier, which was the exact same gym chain. It was another Lifetime Fitness, and the court said, well, look, here's the waiver they had. This one expressly says, including but not limited to accidental injuries within the facilities, including but not limited to locker rooms, showers, and dressing rooms. So the court said, look, Lifetime Fitness, if it wants to waive premises liability, knows how to do it, but they didn't in that prior case. Now, I agree with the two dissenters out here that I think the waiver arguably covers it. But what this shows is that if the waiver is ambiguous, you're going to lose. I mean, that's the main point of this case, even though there is a valid argument to be made that they waive this. So if we're going to do premises liability, do it separately. You know, have a separate provision that talks about premises and then a separate one that talks about training. And for those of you who have seen any waivers I've done, that's exactly what I do. I will have a separate premises liability portion, so that way there is no question that I'm going beyond just training issues. So speaking of the Geisy, I don't know how you pronounce that. So it actually is it's actually an interesting case too for intentional misconduct. Now, in this particular case, the plaintiff was using a treadmill, and then the treadmill basically became possessed. It started moving up and down on its own. It started starting and stopping and jerking for no reason, and she ended up injuring herself. All right. So the plaintiff goes to the.
Couldn't get off it.
Yeah, and she could. Yeah.
Couldn't get off it.
No, well, if it's going like this, I mean, give her a break. I know that we, our sympathies lie with the gyms, but I mean.
Maybe she thought it was fun.
So Riff's color commentary never fails to make everyone chuckle. So anyway, but here's where the case gets interesting, right? So she goes to the front desk and says, "Hey, this treadmill just became possessed and I got injured." And the person said, "Oh yeah, we already knew about that." And then she's told by a manager later on, "Oh yeah, I knew last night that the thing was broken." So as a result, right, this goes back to the intentional willful blindness, right? If there is no duty of care, if they know that something's broken and they're intentionally not doing anything about it, then it actually moves us from the negligence realm into something that looks more like intentional misconduct. And here's what the trial court actually said. The appeals court quoted it, but it was unclear whether Lifetime had taken any action before the incident to decommission the treadmill, either by placing an out-of-order sign on it, unplugging it, or in some other way making it unavailable and inoperable. It wouldn't have been all that hard to put a sign on it, right? I mean, just handwrite one. Genuine issues of fact existed as to whether Lifetime had acted willfully or wantonly prior to the incident. Now, fortunately for Lifetime, they ended up winning a trial. But this is a pretty expensive lesson for them, right? Because they had to spend, by the time they got to trial, they were probably looking at about $100,000 when you look at medical experts and testimony and preparation and all that stuff, all to have the privilege of going before, in Ohio it's anywhere between 8 and 12 members on the jury, depending on what you select, but all to have the privilege of asking 8 people to decide whether they were liable or not. I heard the groans in here when you heard the facts of the case. If I were Lifetime, I wouldn't want to be in front of a jury with those potential facts. But here's the point, right? If there's something that's broken or you think might be broken, do something about it. Do something about it immediately. And if you have staff or employees or other fellow partners or coaches, tell them the exact same thing. Have that actually be part of your gym policy so that you don't have issues with that. This is another an interesting case, and I'm going to sort of give you the facts. They're long facts, and it's a little, because it deals with a college football team, it's not entirely applicable to us, but I think it's very illustrative. So in this case, both plaintiffs were students in the college who played on the football team. And they were doing something called the Oklahoma drill. So any football players, yeah, I'm assuming that a few people know what the Oklahoma drill is. So the first plaintiff ended up tackling with his head kind of down and ended up fracturing his T7 vertebrae. And so one of the college's first responders came to his aid and tried to help him out. So there's plaintiff number 1. Plaintiff number 2 got what he referred to as a stinger, which is basically that he had numbness and he had some pain that was radiating up and down his arm. So a second first responder, this is starting to sound like Fifth Third Bank. So the second first responder came to him and said, "Hey, look, as long as you're feeling better, just go ahead and go back into the drill. You probably know what's coming next. So he goes into the drill again, and he ends up suffering a traumatic brachial plexus avulsion. I have no idea what the hell that means, but I'm sure the physical therapists and some of you do. It sounds really bad. Yeah, it sounds really, really bad. So here's where things get interesting. Both of these first responders were originally hired as athletic trainers. And they signed a form that said they were going to be athletic trainers. It gave their job descriptions. They represented that they were going to have the qualification of an athletic trainer, except one problem: they both failed the athletic training exam. And their professors, after they realized that these people were trying to do athletic training, their professors contacted the university and said, "Hey, I have these folks in class. They're not qualified to handle this." One of them even referred to her former student as well below average, right? So that's a problem. And then, so what would the college do, right? If it realizes, wait a minute, these people aren't qualified to be athletic trainers, what would the logical thing be to do? You know they did it, right? They gave them a different job title. They called them first responders instead. Right, that's why they were referred to as first responders. They never bothered to sign a new employment agreement, though, right? And they never bothered to have different job responsibilities. So the whole thing looks and smells pretty badly, right? Now, for those of you into Texas football, does the name R.C. Slocum ring a bell at all? So, legendary Texas A&M coach who was later put in the College Football Hall of Fame. He was with Texas A&M from 1989 to 2002. He actually did an expert report in favor of the plaintiffs, and he said that in all the years he had ever done football, he had never seen this Oklahoma drill done in a way that was so unsafe and so dangerous to the athletes. A lot of things are going really badly for the college here, right? So what did the college do? It said, well, but we have a waiver. So it's okay, we have a waiver. The court said that this waiver did not cover this instance for two reasons, okay, two separate reasons. Now remember, when we're talking about waivers, conspicuousness fairly covers the circumstances, have to expressly mention negligence, can't waive intentional. What do you think the two reasons are that this waiver was invalid in this particular case? Yeah, no express statement of negligence, right? It says just all liability claims, demands, actions, and causes of action, but it doesn't actually say including due to the negligence of the college and the employees, et cetera.
Plaintiff can argue that there was an intentional misconduct in the way that the trainers were reassigned.
Exactly. Yeah, and as Sully points out, the other problem here is that it actually looks like willfulness. I mean, these are pretty egregious facts. You have somebody who's clearly not qualified to hold the position. They just give them new titles, but have them do the exact same work. It looks bad. And then apparently the coach is, a buffoon too, and can't do and has two serious injuries while doing the same drill that high school and college football teams do pretty much every day during the practice season. So that's it for the waivers. We have a couple miscellaneous ones.
Brody,
Oh yeah, sure.
well, what was the adjudication? What was the outcome of the case?
Well, we don't really know because all the court was deciding is, does this go to the jury?
I see.
So yeah, there's a procedure called summary judgment where you can basically throw a case out before you get to trial. Summary judgment is where defendants want to win, right? Because they don't want to, trial's too expensive. And so most of these cases involve where the defendant is moving for summary judgment and saying, look, we've got this waiver, it covers the circumstances, just throw the case out now. We don't even need to go to trial. And that's what happened in that previous case. Now this one is just a kind of a funny one. It's a trademark infringement, and you can probably guess. So CrossFit, of course, is very well known, and there was a competitor who decided to call their workouts CrossFit 24 with a K. You can probably guess how this one turned out. So now this is a kind of a silly case, right? I mean, in a way it's almost terminal silliness, but here's why I bring it up, right? So number one, don't do this, right? I mean, if you have a competitor, don't just change a letter or do something that's similar to it, or copy their slogans or anything like that. Bad idea. But here's the other reason why I bring it up. So it is important for us as we grow as an organization to make sure that our brand is protected, because as Rip talked about on Friday, what we don't want to have happen is have our quality diluted. And one of the ways that your quality gets diluted is when people do knockoffs. Now, you may have situations where people claim they're starting strength coaches, or they use words that are similar to starting strength. Be vigilant about it and report it if you see anything like that, because we need to be active about this. CrossFit defends its brand very well, and that's why it's able to maintain a reputation. And it's the exact same, and it's the same thing with us. We need to make sure we defend that. Now, the other one is a negligent hiring case. And this involves it's not in the training context per se, it involves a masseuse, but a woman goes to a massage therapist in a hotel spa, and she ends up getting groped on her buttocks, in her genitals, on her breasts. Really, like it's bad stuff. So she goes and reports it to the management, who ends up not really doing anything with this particular masseuse. Now, when the masseuse was hired, he had to report any criminal convictions, and he only reported one. He said that he was fleeing and eluding the police on a motorcycle one time, right? So I mean, yeah, you shouldn't run. If the police are trying to pull you over, you shouldn't flee and elude them, but it may not be that bad. And then he also provided a resume which showed a 1-year gap between when he was, between when he was hired and his prior, and his last job. Well, after he was hired, he disclosed to them, oh, by the way, during that 1 year, I was actually working at another spa. Now, you probably know where this is going to go. What did the hotel spa not do when they hired him? Right, they did not do a background check. They did not do a criminal check, and they did not talk with his prior employer. Had they done a criminal background check, they would have learned that he had been arrested 3 times for fleeing and eluding the police, and was arrested and charged for attempted rape of a minor. Now, those charges were dismissed, but the point is he was charged with it. Had they contacted his prior employer, they would have learned that he was fired because he groped a male client during a massage. Well, what do you think they would have done if they knew that? They would have not have hired him in the first place, at least if they were smart, right? So what is the lesson? And so, needless to say, this, the hotel moves for summary judgment. They say, look, the guy did what he did, but we're not responsible for his misconduct. And the court said, no, you got to go to a jury on this. You got to go on a jury because it looks like negligent hiring. Okay? You all have a duty to make sure that your employees are qualified and aren't going to injure people. Now, of course, massage therapy is a much more sensitive area, I think, in terms of intimacy than coaching is in a lot of ways, right? Because usually you're dealing with people who are nude or semi-nude, and at least, I think I'm glad at Wichita Falls during an open workout night we don't have a bunch of nude and semi-nude people doing stuff in the squat racks, but. Yeah. True, I'm not there all the time, but the point is, right? This is something we all need to take seriously. So if you're going to hire somebody, do a background check, right? Talk to the people that previously employed them, because it's on you if there's a way that you could have learned about misconduct and you didn't take the opportunity to, right? You could end up being liable for negligent hiring. And by the way, in something like this, I don't know, does it qualify as arguably reckless under the circumstances? I don't know. I mean, a waiver might not even have protected against it.
How do we do a background check?
So yeah, question is how do you do a background check? Something I will mention, by the way, is before you do background checks, check your state law as to what you are and are not allowed to consider. A lot of states have laws that say you cannot consider arrests in hiring decisions, which makes sense because sometimes people get wrongfully arrested, wrong place, wrong time. Turns out it's not a big deal, whatever. So, so try to look at what you are and are not allowed to use so that you make that hiring decision. But in terms of the background checks, there are usually organizations that can do that. If you just Google in your state, background check, insert state, there are usually several organizations that can do it. You can order a formal law enforcement one in a lot of areas. I know in Ohio you can contact the police department and get criminal background checks. And then in terms of employment, contact their prior employers, and if there's an unexplained gap in their employment, ask them about it and try to figure out what that is. It may be innocuous, but in this case, if they would have inquired about it ahead of time, they might have learned something a little bit more interesting, right? Okay, so that is all for waiver and miscellaneous cool stuff. Oh yeah.
So after he's hired, he admits, oh yeah, I was working at another Masonic facility during that year. Are they liable then to follow up after he's hired, potentially fired for that? Is that part of the negligence that they did not continue, or is that considered not applicable?
Yeah, so the question is, once the employer learned that he had this other job, were they obligated to look into it and fire him if it turns out he didn't, either didn't disclose it or whatnot? I think it's a judgment call on the circumstances. There's no requirement. Now an employer may say something like, if you lie on your job application, we fire you, no questions asked. There are a lot of companies, including I think UPS actually has that written into their agreements as well. I mean, you cannot lie or omit things on your history. But let's just say that he worked at this prior place, they called up the place, and and his former spouse said, yeah, he was a terrific employee. Lots of people loved him. Apparently he went to you guys for the money. Well, I mean, do you have to fire him? I don't think so in that circumstance, right? If you call up and there's something bad, then that's where the negligent duty starts coming in, right? I mean, you're only responsible to act on the information that you either you had or that you could reasonably get, right? Without extreme efforts, right? So background checks and simple things like that. So that's where that comes in. Is there how much time do I have? I don't have a clock here. 9:30? Oh, yeah, well then, we're great.
Brodie,
Yeah.
what if the company they called he used to be employed by will not disclose why he was fired?
So interesting question. What happens if they call the prior employer and the prior employer says they will not say why that person was fired? Now, it depends on the state. Nick is right. In some states, they're not allowed to say that. And in other states, they don't say it because they're worried about lawsuits. So it's basically they cover themselves on it. They may say the person was involuntarily terminated, but that is all they're going to say. At that point, you can only do your best, right? I mean, if you can't get the exact reason. Now, in this particular case, the court seemed to believe that they actually would have gotten that information, right? So at least in Pennsylvania, it seems like they could have gotten that information and acted on it.
Something you can say, you can ask is, are they rehirable? Are they rehirable? If they're not rehirable, it's probably let them.
I believe Texas says, Texas law says that when you ask about a previous, about a prospective employee's previous employment situation, you are able to say, yes, they were employed here. And you can answer the question, are they eligible for rehire? That's all.
Yeah. And so, yeah, what Rip and...
You can't ask about why they were fired. You can't ask about for references from the previous employer. You can only ask, were they employed there, and verify the dates, and ask if they are eligible for rehire, yes or no. That's it.
Yeah, so as Nick and Rip said, so at least in Texas, you can ask them, you can ask the prior employer, are they eligible for rehire? Now, let's say they were fired because they didn't show up to work, they showed up to work late 3 times or something like that. They're probably eligible for rehire under that circumstance. They may not be. I mean, the point is, if they're not eligible for rehire, they probably did something that's a little bit shady, right? I mean, if you're willing to say no, under no circumstances would we rehire that person. So, just again, this is an issue of state law. You may be constrained a little bit. But the point is, try to do the best you can under the circumstances with the understanding that your state may be kind of restrictive in what you're allowed to ask, what kind of information you're allowed to use, and the like. Facebook's becoming an area too, whether you can look at somebody's social media account. That's starting to become a hot topic as well. So Title II and anti-discrimination. Now, why am I talking about this? Right, here's what Title II says. And you've probably learned about this in history class. Back in the days of Jim Crow, this was the law that basically broke Jim Crow. It said that in places of public accommodation, you cannot discriminate on the basis of race, color, religion, or national origin, right? And there was a separate provision that said states can't enact laws that require discrimination either. So there were it attacked it from 2 different areas. For pretty much everybody in here, this will apply to your gym. If you offer services generally to the public, if you basically say, call me up and I will take you in, you are probably a place of public accommodation. There is a private club exception, but private clubs are usually like, your elk lodges, your country clubs, where it's, very limited membership. You have to be nominated by somebody before you go in. You pay dues and it's used to upkeep the whole thing, but it doesn't actually go to an owner. Things along those lines. So private clubs will probably not apply to anybody in here. It's probably going to be places of public accommodation. Now, where this gets interesting is when you start enforcing neutrally applicable gym rules. Right? That's one area where this could come up. Because let's just say that you enforce a rule against a gym patron from your gym, and they happen to be a member of what's called a protected class. They happen to be black. They happen to have a non-mainstream. Well, I don't want to say non-mainstream. They are a part of a minority religion, relative to American Protestantism, for example. So this actually comes up, and there are 2 cases I'll talk about. One of them is Galarza, which is out of Florida, and this was a race discrimination case. Now, in this case, there were a group of boxers and their trainers who all went to the gym, and I think this was a Lifetime Fitness gym, actually, doing business, or that was their DBA, so they were all black. They go into the pool to do part of their training regimen, which is basically like an aggressive swimming type of exercise for cardiovascular fitness. And while they were doing that, their trainers were in a corner working on training plans. So an employee of the gym kicks them out because they're violating the no outside trainer policy. They say, look, we don't allow outside trainers. You have trainers who are writing routines down in a corner. You have people who are, the gym believe they were doing those routines in the pool. Whether they actually were or not is disputed. So they kicked them out. So the boxers and the coaches ended up bringing an anti-discrimination lawsuit. And they said, look, we were kicked out because we're black and people got uncomfortable. The court found that there was no evidence of discrimination. And so as a result, it threw the lawsuit out. Why did it find this? Well, number one, there was no evidence that any similarly situated people of different races were treated differently. So there was not an example for example, there wasn't a situation where there were white athletes with white trainers who came to the pool and did the same thing or a similar thing and were allowed to stay. Right? There was no evidence of that. The other now there was some indication that this particular gym always gave a free warning before they kicked people out, right? So they'd say, don't do that, and if you do it again, then they'd end up getting kicked out. They didn't, obviously there was no warning here, it was a first-time offense. But what the court found is, there were two occasions where the employee who threw these folks out gave a warning and then threw somebody out. One of them was white, one of them was black. So it looks like they're treating everybody more or less the same, right? The takeaway from this case is just treat everybody the same, right? Enforce your rules the same way across the board. If your membership agreement says no outside trainer policy, and I don't know if any of you have that. My guess is since a lot of us are sort of private session, it's probably a moot point. But if you're going to enforce a gym rule, enforce it evenly across the board. Don't let an inference of discrimination occur because you're treating one person differently than another who happens to, share a different characteristic. The other one is Fall v. LA Fitness, and I covered this last year, but I think it's worth repeating again. This is a religious discrimination case. In this particular case, a Muslim gym patron was asked to not pray in the middle of a walkway. He was praying, blocking traffic, people couldn't get by him. And so he brought a religious discrimination action and said that they were discriminating against him because he was Muslim. The court ended up throwing this lawsuit out, and they said there was no evidence of discrimination for a couple reasons. Number one, he was allowed to pray elsewhere in the gym. So they weren't stopping him from praying, they were just stopping him from praying in that particular area. Number two is there was no evidence that there were other people who tried to pray in that area and were allowed to do so. There weren't, for example, Christians or Jewish people who were praying in that area. Take the two together, there's no evidence of discrimination. Now, Rep made an observation last year, which I think is worth repeating here, which is that they could have avoided this in large part by not even bringing the idea of prayer into it, right? The gym employees said you can't pray here. What they probably should have said is you can't be blocking this area. It doesn't matter what your activity is. It doesn't matter if you're taking a nap. It doesn't matter if you're having lunch. It doesn't matter if you're praying. You can't be in this particular area. And so that way it looks even less like religious discrimination. Now, as I said, in this case, the gym applied its rules evenly across the board, so there was no issue with that. But try to, try to avoid bringing religion into it if you can avoid doing it.
The offense is that you're a pain in the ass. Not that you're praying, you're in the fucking way.
Speaking of inimitable.
Yeah, get out of the way. Get out of the way. Doesn't matter what you're doing.
Oh yeah, we'll start here and move over. Yeah. So the question is, what if you, if I can just kind of summarize and tell me this is right, what if you have trainers or employees who are basically enforcing things differently? You have one trainer who kind of lets things slide on a policy, you have another who lets them in. That could potentially be a problem. Now, it depends on who's being let in and who's being denied, right? If it's basically completely arbitrary and people of, let's just say people of all religions and races are either being, it's being enforced against them or not enforced against them, it might be hard to raise an inference of discrimination. But if you have a history of not enforcing the rule for some people, and then suddenly you enforce it for someone who is a member of a protected class, that looks bad. Now, there may not be a discriminatory intent behind it, but it smells funny, and that may be enough to get to a jury. Now, in terms of the question of, what if employees do things differently, employees are agents of their gym, right? They're agents of their employer. So whatever they do can be attributed to the gym, right? So I think the way that you avoid this is by telling anybody who works under you, these are the rules, we expect them to be enforced. If you have a question as to whether to enforce it, contact somebody who's a manager or an owner. But be careful of this stuff. We want to make sure these are consistently enforced. So that's I don't know if did that answer?
Pretty much.
Okay. Anytime you inconsistently enforce rules, it can always lead to a potential of there being either, at best, misunderstandings, and at worst, inferences of invidious discrimination. And then suddenly we are into Title II and state analog worlds, which is not a good place to be. So, yeah.
For public accommodation, does that apply when I'm training people out of my home studio?
This is a question that CJ asked last year, and the question is, does this apply if you train people at home? Because it's your home. I have not been able to find a case that addresses that specific issue, so I'm going to say definitely maybe. But here's my instinct, right? Places of public accommodation means you are offering services to the general public, right? If you are operating a home gym where you advertise generally to the public and anybody can contact you and try to set up an appointment, that looks like a place of public accommodation, even though it's one person operating out of home. I don't, now admittedly the Civil Rights Act was passed well before the advent of the internet, which has complicated a lot of things. And that's sort of, that's made home-based businesses a lot more common than it used to be. But my instinct is you are probably a place of public accommodation if you are offering the services generally. So even if it's a home, even if it's just like, a studio as big as a closet that you happen to rent, it's sort of, I think it's the same issue.